We'll go and call the meeting to order at 1 p.m. Agenda item number 2 is discussion regarding commission initiatives for 2024, including broker associate and broker succession. I'd like to maybe spend a little bit of time on broker associates. I believe Commissioner Brown has some thoughts and some ideas, concerns, or something he might take to BRAC or something.
Well, I just had a thought based on the conversation that started with broker responsibility working group and now is in BRAC. And with an upcoming legislative session in front of us, does it make sense to start working on broker associate as a defined term? No rules around it, just having it as a defined term. So as we get better ideas on what rulemaking around that would look like, we actually have something to make a rule to. That was all I thought.
Agreed.
I like the idea for a definition. I think we've had the conversation before is we have broker associates. And it's in our policy and procedure manual that they have to notify us if they get a letter. In the perfect world, I would love for when they look up our office, they see what broker associates are there. I would love in the perfect world when they get a complaint, I get it, because I'll be perfectly honest. I think I can answer that complaint better than they can, maybe based on experience from dealing with it. And I think that's really, I don't want to ever limit their liability. I still like the fact that they are solely liable, but yet at the same time, if they get a complaint, it's on the office. And big town, small town, whatever, it's, well, you heard what Renee Harvey's agent did. And so, I mean, I'd love to work that way. If it has to start with the definition, I mean.
And I agree with you on those two things. We've had that conversation. The public being able to look up on the website and see that somebody's associated with my brokerage. And if they get a complaint, I get notified.
Does the definition have to be statutory?
Well, both of these are statutory changes. So we've actually got a slide.
Could we not link the relationship with the sponsoring broker by rule?
It's not a sponsoring broker. So
I'm sorry. Yeah, business entity broker.
So
Yeah. Okay, never mind.
let me just, as a walkthrough also for the public members, and also just, I think it's helpful to do this. You've got a broker's license. We've got one broker's license, right? We've got and I just really botched that. What we're really talking about here generally is you've got like a sponsoring broker who sponsors sales agents, right? They're part of the business entity. So let's just say, ABC Realty, the sponsoring broker is Vanessa Burgess, and I sponsor all these sales agents, and ultimately I'm responsible for their acts of brokerage, right? And there's a regulatory relationship there in statute that provides for, if a sales agent messes up, we're going to automatically enjoin that sponsoring broker because they're supposed to be making sure that that person is in compliance with the law, right? So that's how we're currently set up. We also have these, I'm going to say things, but I guess they're individuals, called broker associates, who maintain that same broker's license. It's the same license, right? The individual broker's license, not the entity license. So they have all the same, they've all the same qualifications as required of a broker to sponsor agents. But you've got folks who are brokers who want to associate with different brokerages. So let's say, go back to ABC Realty, Vanessa Burgess is the designated broker, but if I want broker Abby Lee to also do work under ABC Realty and use our advertising, our signage, whatever it is, or let's say sales agent Summer, who's worked for me for 4 years, wants to get her broker's license, and that's something that I encourage because it means there's higher standards associated with what she's doing. She's going to take more education. It's a little bit of a path upward for her, right? From going sales agent to broker, but she's still with ABC Realty, which makes me a lot of money. I'm gonna say a lot of money, I don't know. It's my pretend world.
Like-
Say a lot of money, tons of money.
We put the broken.
Yeah, there you go. And so those end up being the two scenarios where you have essentially brokers working under a brokerage, not for, because we've got all the independent contractor stuff, but working under there. But from a regulatory standpoint, it's the same license. It's a broker's license, right? And in my example, broker Abby may want to do work for multiple brokerages, because I don't allow for any farm and ranch or what. I have something and she wants to do that and she's able to go do that at Denise Sample Farm Properties brokerage. And that's okay because she's got a broker's license, right? And so I'm not responsible for her acts from a regulatory standpoint. If Abby gets in trouble as a broker associate from TREC side, unless I have somehow, facilitated this and done my own bad deed, we're only going after Abby here. Now, if Agent Summer did something wrong, you're going after Abby and me because I'm a sponsoring broker. Broker associates, from a regulatory standpoint, it's something we really only recognize in our advertising rule, and that's to require them to follow the same, advertising requirements to list the brokerage they work for, et cetera. So what we've heard in terms of feedback from this commission and also from Broker Responsibly Working Group is a desire to show a broker associate's affiliation with a brokerage, including, I imagine, unless you're going to create a definition that doesn't allow for this, multiple brokerages, right? So in the scenario where Abby wants to work for do some work for my brokerage and some work for Denise's brokerage, that's okay. So be showing those affiliations on the website, which aren't currently shown because there's not a regulatory relationship. And then the second side of the other initiative on that you asked us to explore was the feasibility of notifying the brokerage when a broker associate has a complaint against them. And then again, from the regulatory standpoint, we don't notify the brokerage because we stop at broker. So once we found a broker to blame, if you will, that's where we stop. Now, the feedback that we get is, yeah, but as the brokerage, I want to know if one of my broker associates has a complaint against them. And also if there's going to be a lawsuit, which is not a regulatory consideration, is a stakeholder consideration. If there's a lawsuit, don't think that they're not naming ABC brokerage because they 100% are, because that's where the money is, or that's whatever. That's who I thought I was working with, those kinds of things, and so we know that is a consideration because those of you who are in the industry have raised it. We've heard it on the BRWG side of things. The thing to be mindful of when it comes to broker associates, and Commissioner Brown mentioned this idea of a definition in statute, is, this would be TREC for the first time wading into the waters of regulating the broker associate relation. And while this isn't a consideration of ours, you always want stakeholder support, you may actually be increasing the liability that you speak of, because now you've got the government in here saying, yes, there's enough of a relationship that we post you on our website as connected, and we provide you notice of discipline whenever somebody messes up, meaning someone's messed up, and what actions have you taken, and so where does that lead to? I am not saying that. This is why I say this in all my committee meetings. I don't have a personal dog in the fight, if you will. I think that's the term. I just want to raise to you what the considerations are, or the hurdles of doing this. For both of these, it would be a statutory change, so the time is right. Later on, and once we've gone through the update on the initiatives, there's a point to talk about the legislative initiatives that this commission would like to see move forward, right? So these are, right now, we're kind of thinking about it, we're walking through these ideas again. And then that stakeholder input component that I just mentioned is important. And then you'll need to think, okay, when it comes to broker, like the posting on the website, what does that look like? We touch a license at application renewal and then, potentially an enforcement, but that's not really a factor here. Is it a self-serve thing? Do you want multiple affiliations shown? What does that look like? That doesn't have to be decided right now. These are just the considerations. I think the stakeholder input is significant here, especially in terms of what I just talked about with the civil liability. I know it's not our consideration, but we know it's a consideration. And I just wanted to point out, you may actually be, if I were taking this case, I'd be like, well, look what TREC says, right?
Yeah.
So there's that consideration. And you'd be, in terms of like connecting them to an enforcement action or whatever definition that you end up creating, it's essentially carving someone with that broker's license out into a sales agent, which is a big shift to how your industry is currently regulated and set up. It doesn't mean you can't do it. I'm just pointing out what, that's a significant shift when it comes to broker associates. I imagine, the example I gave with Summer's been an agent with me for 4 years. And part of the reason she wanted to come work for me is because I provide all this wonderful support and I help her take these classes and get the experience. And then she gets to go become a broker, which is so great for her business opportunities, things like that, right? I mean, we know that that's a thing that people do. And it raises, it potentially raises the professional bar there because you've got brokers. What does that look like if we're carving out the broker associate to essentially still have to meet the standards of like the broker and a sales agent? What does that do to their license in that context? And there are folks there are states that do it. I just want to present all of the considerations that we have, and you don't have to decide this point right now, but we are going to look at it just a little bit. So if you want to talk about it right now, that's what I wanted to
for that slide if we want
to the legislative slide.
No, it's like 2 slides from here.
Yes,
is that initiative?
They're basically the same, the considerations. So the considerations, this is the one that's showing the affiliation on the website. And so how and at what points is the information collected? Do you want to talk about multiple affiliations? Stakeholder support, I think I've covered what could potentially be. But there also may be a lot of people who are like, no, I love this idea. This is so helpful. And for the consumer, it's super helpful to be able to track down, where they are.
From the consumer side of it, they don't understand
Right.
or care about, frankly, the difference. And from a outside of regulatory, if you're talking about complaints, lawsuits, demand letters, the like, there's no distinction. So, as a practical matter, in your day-to-day business, back to, Scott's comment about, you really, would probably like to know and help them earlier because it's going to end up back in your lap later.
Right now, do you feel like you're
Bigger.
flying blind?
Yeah.
Yes.
Okay.
But the other thing is, the consumer, I mean, so that's my side of it. But if you really look at the consumer side of it, your comment, Chance, they go to your website, here they are, they show up as with your quote agents, it may say broker associate, but, they don't know what.
And Chelsea, to answer your question, I don't think we feel like we're flying blind because we have a good grasp with our policy procedures and we talk to our
Well, yeah.
broker associates. But the general public and the other brokers out there are probably blind.
Well, we keep talking about how, it might open up liability and it might kind of open yourself up, but I'm guessing it's
It's
also
already
the
there.
other way.
It's,
Yeah.
It's there with the public, maybe not with TREC.
Yeah.
Yeah.
yeah, they're carrying my business card, they're carrying my E&O. It's
Yeah.
already there.
Their attorney, when they're mad, never considers doing anything other than tying you into whatever.
So if a
claim is
broker
also.
has association with two brokerage firms, right?
I don't know of a broker associate that does that. And I guess,
Got one.
yeah,
One.
one broker here and one broker.
Love it.
Well, see, the reason is the question is, what do you have in your independent contractor agreement with them? Because, if your independent contractor agreement says something along the lines of, hey, if you're conducting residential real estate, in the state of Texas, blah, 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 that's, exclusively done with me. Now, it could say only in certain counties, or it could say other things, but
So let me kind of, so I've got two brokerage firms, one broker that part-time over here, part-time over here, right?
Mhm.
They each have their own separate transactions. One has nothing to do with the other, right?
the brokerages,
The brokerages,
Mhm.
right? And so let's talk enforcement, right? Let's say the broker does something wrong in a transaction that was styled under this brokerage, right? From a TREC perspective, it's all.
Well, that's right.
This
that's
has
right.
nothing over here.
well, that's true. And I'm
Right.
just saying that reason there probably aren't many, I'm not aware that I have any.
That's one example. The
Yes.
second example is from a consumer
Yeah.
perception or
Yeah.
protection standpoint. We've got two brokerages, one broker and the consumer. The transaction goes south. Now, when the consumer wants to file a claim, he can file a claim this way to both, right?
Well, sure. And of course, I think also who in that scenario, so I'm the broker associate.
Right. And so you start thinking about, okay, broker one knows that this broker is working for brokerage two, right? And so at some point, you have shared responsibility in the actions of what he does, no?
You could, except again, the relationship you have with this broker associate is defined with an independent contractor. And this independent contractor agreement typically, I don't know about everybody, but typically says, hey, if you're doing this type of activity, and in our case, I think it says in the state of Texas, but it could be amended, but
So
then you have to do it with us.
Then, for example, the one agent I have,
So
broker associate I have that does, we had a separate amendment to our ICA drawn up specifically
there you
to
go.
address that
Yeah.
by our attorney. But even then, now because of all these new data sharing rules and all
Yeah.
this stuff that's happening inside the MLS space in our industry, we've gone back and revised our ICA that if you want to join an MLS outside of your primary membership, I have to put it in writing that it's okay first.
Yeah, we do that too.
But from a regulatory, it does not go to the brokerage. It stops at the broker.
Right.
The regulatory, the consumer will go to the brokerage.
okay.
And also, yeah, and also,
So yeah, from an
Regulatory.
enforcement standpoint,
Right.
it's gonna go to him because he's a broker,
Correct.
right? Not the brokerage.
But at
Well-
least CC me on the email.
but
So
No,
why-
that's-
so why
that's
would
what I'm
you-
asking for.
So why would you want, what are you trying to achieve? I guess is my question.
Well, number one, like Scott said, because we have responded to these before, and this may be this person's first time doing it, we can help them craft a better response. Number two.
So you're
is
just
that
doing it out of
something
the
that's
kindness
gonna-
of your heart? I mean, you're not,
no,
What are you
No,
trying to-
it's
what are
our
you trying to protect?
reputation in the public.
that
it's your company's reputation. It's also your company's joint liability.
Like, you know,
If that
in
were
E&O,
to-
which-
if that were to go up another level.
Yeah, I mean, there's a whole nother piece of this thing that is equally, if not sometimes harder to deal with.
what?
okay.
And that's over here on this
So let me play.
civil liabilities.
Let's say that the broker is in association with two brokerages and doesn't notify TREC of one or the other, which is what they have now, right? Or they do?
No, they have no notification.
No notice.
No notification.
Right.
And you want notification.
Which you could do in your policies and procedures, but you
Right.
want it to be a requirement.
Yeah, I mean, you
Or
can
you
have
want it to
it
be from track.
like in ours, it can't happen technically. Because we
Don't allow it.
don't allow it. Now, of course, that doesn't mean
They don't do it.
that they don't do it.
But if they do it, our defense
Is
is
you have the policy.
we're only responsible for their authorized act.
That's
So
true.
if they do it under the brokerage and our PNP says no, then I
Right.
think we're good.
Yeah,
Nothing to
no,
do
I,
with that, right?
We're the
So-
good attorney.
yeah, now, here's the thing, back to whether it's shared data or whatever. Is this person hypothetically, it's doing business with multiple, let's say two in your example. When they're doing business with broker A, are they only communicating from broker A's email accounts and in marketing and all this kind of stuff? Or what typically happens is they, it's all over the place. So if you're the consumer, you're probably going after both of them because you don't know.
And you're having people help you with your transaction from one and you're at another. I mean, it's all.
It's messy now, which is why a broker associate that really wants to do business ought to just do it on their own. I mean, they ought to just be a broker. I mean,
Do we have a consensus that we want this and are we doing Brack's job?
yes, yes.
Give it back to Brack to come up
Well,
with
that's what I'm saying.
They
We
gotta-
have a consensus as to where we need to go.
I think without doing this, we actually hamstring.
Okay.
I think we need a legal definition of broker associate in order for BRAC to actually look at rulemaking.
Well, I mean, they gotta brainstorm and they gotta,
Vanessa was coming back with some suggestions next meeting, right?
On a definition?
I thought you were coming back with something.
This might be it.
I haven't gotten there yet,
That's fine.
to be honest. I'm like, oh, we just finished that season. Okay, so it sounds like we like the idea of both of these moving forward, right?
Well, it sounds like they just want a definition of what a broker associate is so that the rest can be dealt with at a later time. Is that right?
Well, I guess
I shouldn't have interrupted.
I guess that begs the question. If we have a legal definition of broker associate and we want to go affect either of these two things, notification of a broker at time of disciplinary action,
and tracking.
registration on the website. Are those inside of our rulemaking authority or is that a statutory change?
See, I don't even think we need a broker associate definition to say you must register what brokerage you are working under their marketing plan. And your marketing broker will be notified. I don't know.
So both of these are statutory changes. It'd be a change in the information we're collecting. We always need to point back as to our authority to, make a
Correct.
change. Notice, so are we talking just about like the notice that we're investigating? Is it the notice of alleged violation? Right? That's the document.
Yeah.
I'm not saying
It
that.
doesn't affect
Okay.
enforcement, does it?
What?
It doesn't affect enforcement of anything.
Well, this is what I'm asking the question of, are you talking about just the notice of alleged violation?
Right.
Going to the brokerage, the affiliated brokerage or
affiliated
brokerages?
Yeah, that's what I'm talking about.
It doesn't affect enforcement at all. In fact,
It just affects who we communicate with.
it's-
Well,
you communicate with the broker anyways. Right.
Notice a complaint.
What, I'm sorry, say that one again?
So if the broker does something wrong,
Yeah.
it's all on him. It's not even up to the brokerage.
Right, for a broker associate,
Yeah.
but what you're saying is that you want that notice to go to the brokerage?
Any associated brokerages.
Yeah.
Yes, so it would be the notice of alleged violation, but nothing else?
Yep.
Right.
Okay.
That's all I want to know, right? At the
Yep.
end.
That's it.
From then on, we
From
can
then on.
handle it
Yeah.
internally.
And so the regulatory reason for that shift is,
Protect the consumer.
Yeah. Because the consumer doesn't.
Because brokers can better help their.
No, but that is, I mean,
The
honestly,
associate broker can
Well,
help them out of the kindness of their heart.
well,
No, let's not say, it's not the kindness of my heart.
Yeah, you're
Person's going out and doing stuff that against my policy procedures or against anything else associated with my company, they're not gonna be associated with my company.
And we need
They're
to
out the
know.
door.
It's full disclosure.
Right. Number two is if it's a training opportunity, if it's something that I can help them be better so they do serve the consumer better. And that's why I want to know. If I don't know, I can't do anything about it.
You get blindsided.
Okay, and so then I'm just gonna, so you want the government
What's the
to
blank
take
mean?
this role
What's that?
and say, you're connected enough that we are
Like-
going
like
to
the-
notify
and
you
the-
of the
Other than
violation.
somebody that you associated with.
And we believe that is important because
you're lying.
we as a regulatory body think it is important that we notify
Also
you.
Financially, because of.
As a consumer,
Advisory role.
as a
They're gonna come.
consumer, if I'm under chance as a broker associate and I do something wrong
They're gonna say, they were.
and you
doing their
notify
work.
me
They were working in here.
and you have not notified this huge company I'm working under theoretically, I don't think you're protecting the consumer because you stopped at the one person that did it and not the entire brokerage. Does that make sense? And the entire brokerage will learn
It's
from
not-
it.
To me, it's not.
But I'm sorry.
No, you can.
Is that entire brokerage in some way responsible for the act of that broker?
No.
That's what that's saying.
Yes.
Yeah,
Absolutely they are.
Absolutely.
in the consumer's mind, they are.
In the consumer's mind.
But in the regulatory mind, in the
Yeah.
mind of the government, is that what we're saying?
And are you sure you wanted to say that? That's exactly right.
I'm just saying the company should know that there was a letter sent to the associate broker. And I don't think you see anything else. If the company ignores it, they ignore it. But at least they got the notice that someone affiliated with their brokerage, even as an associate broker, had a complaint.
Let's say I'm an associate broker and you notify I work for multiple brokerages and I have a.
Let's say one broker. I mean, 99% work for one broker.
Okay, so then what are we talking about if we have associated brokers?
No, what I'm saying is
Broker.
most associate brokers don't work for multiple brokerages. They work for one brokerage.
But they can.
They can, but I mean, I can be drafted by the Mavericks. It's not gonna happen.
So then the issue is just that they're a broker instead of a sales agent. So the
They're just
responsibility
brokers
line.
under a broker.
Yeah.
Sponsored by another broker.
To me, it's not much difference than disclosure and an agent having to advertise which brokerage they're from. It's not much different.
That's a good point.
Yeah.
You would think,
To the consumer.
yeah.
Right.
The consumer needs to know if I'm a broker associate, that my affiliation is with Scott.
Mhm.
Well, period, whether I mess up or not, but that.
Yeah.
They
And
should
that's-
know.
So
In advertising.
So let me-
Letter, all I want is a letter saying she got a letter.
let me take it a step further. I work for her and Scott. I'm a broker. I do something wrong while doing a transaction for her. And you disclose to Scott, are there any confidentiality issues
Yeah.
that I can?
Not with that notice of alleged violation, right?
Well, we have a
Or
furrowed
we
brow.
Notice of complaint.
Notice of the.
Yeah.
So, and notice of alleged violation happens way
Happens later.
farther into the thing.
Okay. That's
Investigated.
what I was trying, yeah.
I
okay.
don't want that first email that goes out, which requires.
Yeah, but I don't
It's one
want,
of my sales.
I don't want Scott to
But
know
I get an
about
email
what
from you.
happened. I don't
It
want Scott
says
to know what happened
You have
with
however many
another
days,
broker.
15 days to respond.
That you-
I want that if
you
it goes to one of my
notice-
brokers.
You want
Commissioner Mingy, that is so.
Notice
Where-
of complaint. Okay, sorry, that's what I was trying to ask. So
I never heard
it's the notice of complaint. it's
That's
not
it.
the alleged
Yes, thank
I
you.
thought that's what you all were talking about.
Yeah.
So
No.
multiple brokers that,
No.
Well, it can be that, and
It
that's a
can- it
fair
can be that.
question, which is
But
it everyone that they're affiliated with?
Well, that's a
If
good
they're affiliated
hypothetical
with
question,
multiple
but
brokerages
it's rare.
and they get a complaint, then all of those brokerages should be notified. I mean, theoretically, because I'm thinking they registered who they're associated with.
Right. Like right now, at least I don't know how everybody does it, but with us, right now, you change your business address with the real estate commission to my business address if you're a broker associate that's affiliated with my company. That's how we do it. Now that we don't show addresses on the website, it doesn't really matter, but at one time it mattered. I think it's just a very similar type of thing. I don't know, this is in no way, shape or form advocating for a separate license type or anything else. This is just CC me on an email and the public should be able to see who they're associated with. That's it.
Does it create a pseudo license type just by kind of defining this mid-level way of doing work?
No, I don't think so.
You don't think so? It doesn't matter if it does. I mean, in some respects, it almost seems easier if it was created that way.
Like a broker associate license.
Well, my thought is if that's not something that makes sense, then to a broker associate, then the ought to be a broker. I mean, why is it that they want to be a broker associate?
Well, does the broker like broker associates? I mean, I would
I
imagine.
encourage all of my agents to get their.
Yeah.
Well, it's a higher level of competency, right?
Don't understand, but I mean, if they're not comfortable with that disclosure, I mean, they want to be with you for a reason.
So in truth, a broker associate is just an agent of the broker.
No, it's a broker that chose not to take the responsibility and liability of
The
running a brokerage and wants to
Right.
work as they sell, as.
But in reality, they're just an agent, right? And for.
I treat them all the same. How about that?
We treat them all the same.
But we don't.
But y'all
Y'all
don't.
don't.
And therein lies the problem, potentially. And it's, and I think it's back to all this focus on advertising and everything else with consumers. I mean, it's in the same vein. Do they really know who they're working with?
And advertising is very clear. If you're a broker associate, you have to advertise broker associated with ABC Realty.
Yeah.
You cannot make it look like you are the.
So in that vein, then why is it, then why doesn't it make sense if that does, and I agree it does? If this person that's saying, hey, they're, advertising as being one of associated with me, if there's a problem, why wouldn't that this consumer has, why wouldn't I get noticed of that?
The advertising says they have.
The advertising has, they're required by TREC to say they're associated with us, if that's the case. To me, it follows that, hey, if there's a problem, why wouldn't we get an email and say there's a problem?
For my sponsoring broker.
Or associated.
Or associated, yeah.
Associated. I mean, that's all. I think that's what
Sponsor.
we're talking about.
You're not sponsoring, right? That's true.
It sounds like you want to move forward with it.
Yes.
But does that make any sense? The difference?
Oh, I think that's a great argument. I think it's just a matter of how to do that. We don't have the authority to draw that line the way you just described. I think we just need to go get it.
That would be the legislative priority is let's go get the authority.
Let's go get the authority. And then I'm curious to know if there will be opposition to it because of the appearance, at least, of expanding what we don't care about, which is liability.
According to a straw poll at the Hyatt Bar this weekend, there would not be opposition.
I don't know.
That's good.
And it is presented that they are still a broker. They're still responsible regulatory from the regulatory side. But the broker they associate with in his business or her business will be notified if there's a complaint.
I can tell you, there's not a broker in the world that isn't going to be in favor of
Yeah.
You're right.
Is there more information?
Yeah, but there's more
Other than.
agents and brokers, right?
No, I think the how
Well, if
is
they're,
gotta be explored, but
that's
not
an
in-
associate. I mean, agents,
Right.
they're already in for that.
And that's,
It's just-
Oh, that's true. It has to be a broker
The how
associate.
goes to.
The how goes.
That's true.
yeah.
So you probably have more brokers than broker associates.
I don't think there's a broker associate that would have an issue with this.
it. Me neither.
Yeah,
I really don't.
I mean, most of them go, okay, so what?
But that's,
I said I didn't want response.
and you
Most
do
of
need
them
a
are
law
getting
to
their
keep
broker's
that,
license so they can advertise it.
or it can be done with rules.
They can put that on a business card and tell people because it has some more weight. That's why they're doing it.
The
That's right.
info we collect is specified in statute. So we would need to make a change to that. And if you're gonna make a change to the notice of the complaint, that's
So-
wading into the waters of creating a regulatory relationship that doesn't currently exist in
Right.
statute. So
And so
we
when,
wanna make-
like Chelsea was saying, when you take it up to the Congress people, why?
Yeah.
They're gonna ask, well, what are we trying to achieve here? And you say, well, the brokers want it that way.
No, I think it's a consumer protection.
Okay, if there's an advertising violation, broker associate is advertising, working for ABC Realty. They put chance bound broker, not broker associate, and they get hammered on the advertising, where does that go to? It goes to the brokerage. It doesn't go to chance.
So
The line goes to the brokerage, doesn't it? Because I have a broker associate advertising broker, not, does it go to the broker? Maybe
The
not.
broker is responsible for their own
Yeah, okay.
the part of that carve out for that rule is to make sure the consumer is not confused because there's more than one broker in that advertisement, to define that, you know, there's a brokerage and there's just like another person that has a similar license, the same license that's associated with them. So it's just.
So I think that's the
it's
answer.
to
the
Stop the
legislator
confusion.
asked. That's the answer to your question.
On the discipline too.
I think so.
It's just,
If I don't know about the disciplinary action, I can't do anything to make it better. In the long term, protects consumer, that agent, and all the other agents in my brokerage, because I can train to it.
Well, it sounds like, you know, these two are ones that you want to add to. Look, it doesn't matter to me. I
No, you're here to
want
play
to
devil's
share
advocate.
you, what?
You're here to be devil's advocate.
I am,
Do
I'm
that.
here to be the worst,
Yeah,
right?
yeah.
Me too.
And,
I'm the devil advocate.
I mean, how hard can it be?
yeah.
Yeah.
Yeah, you know, I mean,
I've heard that before.
we always want to be mindful of like when the government steps in and starts regulating more and creating new regulatory relationships. You know, we just have to say what that is and why we're doing it and the reason for it, and be mindful of, you know, how it'll be received. And it might be, I mean, sounds like Chance, you know, has asked some people. And we know BRWG or BRAC has had the interest in it, so, yes, Tony?
Take it, Chance, you got it.
I was just gonna say, whenever you go to a legislator with legislation, and I don't know how this will be presented, if we'll be partner with somebody or not, you don't want to have a group of stakeholders who aren't in favor of it.
Sure.
Because the legislators will say, I'm not touching that. They want to be able, they want to slam dunk.
Well, like TR in this case. Would
Why
they,
would be? I can't imagine a reason why they wouldn't be.
because you'd have to have TR on board.
They wouldn't.
Yeah, I
I'm just
can't,
throwing
I
that
can't
out.
imagine.
No, I agree.
There's things you have to circle up and make sure that everybody, because that's the last thing you want to do is have a legislator agree to it and then they find out later.
Totally agree. And I'm just saying, I mean, these guys work a lot for TR. I mean, wouldn't you think
They would absolutely have no
I mean, you
issue.
got to get TR on board.
Yeah, I mean, on issues like this that are really industry issues, they tend to carry it.
They carry the water.
You know, I mean,
Well,
I can't imagine a broker coming up with a good reason not to have that.
Who run the traps?
And I think it's gonna depend on how it's done, but we've got to figure out the best way to do that. I mean, if you have a real broad definition of broker associate that makes it look a lot like a sales agent, I think you're gonna see
Very specific.
opposition. So it may, you know, but that's the part that we need to work on, and whoever else is working with us on it.
Very
Wouldn't it
broker
be-
Associates with another brokerage. As a broker, so just, I mean, that's what it is, a broker associate. They're associating with another broker. Yeah.
Unsponsored.
Okay,
All right.
so I'm gonna move us forward to our other initiative
Good.
that also requires statutory things. But it sounds like we got two thumbs up. Or thumbs up on two items. Okay,
Go.
let's move to,
Wait, question. Has this been brought up to Texas Realtors? Any
Not
discussion?
formally,
Not formally, just at the bar.
Just at the bar, and I will.
in
say
other
that
places.
The mission of, we're going through this agenda in kind of a funny way, but we're accomplishing just what needs to be accomplished. That first slide was all of the commission initiatives. Some of those require statutory changes, some don't. So the purpose of that agenda item is really to give you the status on all of our initiatives. What we're going to get to is what is our legislative agenda, and the reason for that in this meeting is that we're in February. We will not have a workshop in May. And then we'll be in August, right? And a legislative agenda will really be set before then. So our conversations in coordination with Texas Realtors or TLTA or any other stakeholders will be between now and our August meeting. So the direction that you're providing that we just had and that we'll keep talking about is incredibly important. There are a few items in here that are really just updates on how we're doing with initiatives that require no statutory changes.
Right.
Commissioner Russell, we're happy to send you this.
Oh, yeah.
Oh, okay.
I mean, you're welcome to take a picture of it, but we can also send it.
And,
That'd be
and
great.
this is your list, remember at the last workshop, this is the list that you came up with. And so we'll go ahead and, I think Chelsea.
Yes, this is one that's not a legislative item and that we talked about as an initiative to migrate applications that use paper forms to online processes and eliminate paper checks and accept electronic payments exclusively. So our lawyers are reviewing all of the rules that might need to change just to make sure we can do this in like the cleanest way possible, right? That all rules would be accommodated. And then our divisions are looking at what this would mean for them. What paper can we get rid of? Like, what will it take to become completely paperless? Our HR files right now are in paper, but we're working with a vendor to get those paperless those times.
Will this integrates with the new ramp project, right?
Yes, and that's that last bullet. Acela is our vendor for the ramp project, and so we're talking to them about all the features that would need to be utilized.
Was that contemplated already within the original?
Yes, we're working on that.
You guys are way ahead of me.
Oh, that's a good question.
So, and then not included on this slide, but there's a huge communications component to this. Applications that used to be on paper will no longer be, and then of course the no paper checks. We'll need to kind of blast that to the world. It should not be a huge deal. There are a lot of licensing agencies that have moved in this direction years ago. But it will create great efficiencies for us.
And I think the data presented by Tom earlier today reflects a high level of online usage. So that migration will help significantly with that.
This is like just a little bit of an FYI, but it's related to this. We have recently discovered that there's that we still take credit card numbers over the phone. And that, which reminds me of how I used to order clothes from catalogs like a long time ago. But we're going to stop doing that just for purposes of security of those credit card numbers. We found that for the most part, the people asking us to do that are like driving and they just don't want to stop and go to the website to do it. It doesn't seem to be primarily a form of helping people who need the help other than just their driving. So just an FYI that we're moving.
Seems to be a matter of convenience.
It's a matter of convenience and not a necessity. Oh, thank you for helping you.
So is the solution we're sending them a link to pay or we're just directing them to the website?
Well, they would need to like log into their account so it would be you need to go to your account, do that. If you need help doing that, we can show there's an article that says here, click here, then click here, that sort of thing.
Are we still accepting checks for license renewals and all that?
We are accepting checks, but when we roll out Acela, we plan not to. Now, we are creating a component for if we really, really, really need to. Like if there's someone who calls and says, my only option is a check and here's my very sad story.
Right.
Then we want to be able to accommodate that.
Mhm.
But
That becomes way the exception as opposed to.
that's right. We don't want it to just be because someone's more comfortable.
Why wouldn't you do that now?
I don't know. I don't know the answer to that other than it's been, we have had the sense that we've had former commissioners who said, don't you ever do this. I want to write my check. And so we have kind of thought that it needed to be part of a rollout. Any Renata, what am I missing?
In another 5 years.
Not as
we'll need
ready.
to, because we'll all be gone.
take that check to the grocery store and hold up the line.
Yeah, exactly. You're writing a check? Oh, my God.
And put it in the register.
And then you have to log it in the, what do you call that?
And then the lady goes like this.
We stopped collecting like the NSF fee, but we still get a lot of people who write bad checks. And so we don't even penalize them and charge them like a $30 fee for writing us a bad check. We just say, hey, you wrote us a bad check. Can you send us another form? And so
That's an administrative nightmare.
Wow.
Yes.
That's an administrative nightmare. I mean,
so we really.
you gotta uncredit the account, send the check back and.
Yeah.
If you give me like 2 minutes, I can get
No,
to
I'm
that
just
data.
curious.
It's about, I don't know, maybe about, I'd say about 15%.
So 238,000 licenses.
I mean, didn't we, a while ago, we did the,
5,000.
it's like 150,000 a month?
Yeah. Yeah.
Wow.
We get about 150,000 a month in revenue via check.
Right, that's not admin
Yeah,
fees.
we get
That is shocking.
all of our administrative penalties, they're all still paid by check.
Yeah.
And
We're-
There's a
New
bunch,
program
there's a
will allow
bunch of
us to
papers
invoice
floating around.
people so that can.
That's not reflective of just license application fees or renewal fees, because a lot of the
All right.
education provider,
All education.
all of those.
So it's a heavy lift.
But
So from staffs, maybe staff can comment, is it better to accept checks or not? Would you all prefer?
we would love to eliminate checks.
Get rid of it.
Yes.
Yeah.
And so
Oh, you're talking today. I'm sorry. They're very supportive of this initiative.
Yeah, I mean, why?
Yeah, do it tomorrow.
Well,
How's
you
that?
can do it in education tomorrow.
Yes, we can't do it in education because our system is not designed to support that. However, Acela fixes all of that. So while we are
Fine, that's
stuck
it.
with paper apps and checks for education right now, once we get through this project, on everything education will be online as well.
Even the penalties and all that?
Can't speak to penalties.
Or
No,
the
with, this is
administrative-
part of the ramp for them to build a online, like, we can build them to pay their administrative penalties.
Without a check.
Yeah, even the payment plan ones you see, they'll be invoiced on a monthly basis.
Yeah.
Okay, we got nothing else on this one. Gabby, are you in charge? You
That
have the
was
PowerPoint or is that Vanessa?
Look like you're in charge.
a whole lot on that.
Okay, provide education related to advertising requirements and assume names. Who's it?
You lost the meeting.
Is this Vanessa?
You lost the meeting.
Getting back on it. I'm ready for the next.
I'm not completely drawing a blank on this one.
Yeah, I hate it when that happens.
Okay,
So I'm
thank
happy
you.
to do that. So y'all asked us to kind of refresh what we put out there about advertising. It remains a real puzzle for a lot of people still. And so we have some existing communications, but we're working through those. I think we can always improve. And with Sierra on staff too, we can do some videos and other additional types of media that we hadn't done previously, and also push that info out, and also connect with Texas Realtors and local associations and anybody else who wants to help us get the word out. But we have a great relationship with the Texas Realtors comms team, and if we let them know it's something we're trying to build awareness about this year, I'm certain we can get them to help us reach more folks. So we've already started that. We're very close to publishing an article specifically about inspectors and their DBA requirements. So we're doing that with the help of Mike Malloy and Tony Renneria in enforcement. And really it just needs like one more review and we'll be ready to put it out there. So this initiative is well underway.
You mentioned the possibility of a green room later. Do you have the equipment you need for good video and video editing?
So it looks like Shira popped out of the room.
She had her equipment.
Yeah, she was the equipment. No, we do have a new camera. She has some tools that she uses for video editing and a new computer even. As far as the green room goes, we would need other things like, we have a ring light, but probably better studio lighting, maybe a green screen, maybe some stuff where you guys can read a script like you had at A4. So there's some additional things we need to look into. And we've identified a potential space that already exists here in this office. So just be outfitting that with what we need.
Make sure the new building has a green room for us.
We've
I've
talked
been-
about it.
I've been annoying lots of people. I think I annoyed the guy at TechStot because it wasn't part of the tour. And he was like, it's just a green room.
When we've been touring a few different types of workspaces so that we could get an idea of what might work best for us. And the TechStot space was really helpful, but that is on our list of wishes for new space, but it's not insurmountable to do here.
Right.
We just need a small room and
Got a
then,
bucket of paint?
well, it doesn't actually have to be green. I don't know. I have no
It has to be
idea.
green, right?
But the economics are not prohibitive, but,
There's a particular kind of green.
Yeah, it's a specific shade of green.
okay.
Well, if you start one here, when you get to another space, you will know, you will have figured out,
Smells terrible.
well, we need, in addition to that, this, and this.
That's right. That's exactly right. Okay, so nothing to do on this today. This is just informational. Social security numbers. Is this a Vanessa one? Thank you, Summer, for your help on that one. I blanked.
Here, mine. Okay, so there was a request that we research the viability of using social security numbers or other methods for background checks. So a few of us did some research into this idea of social security checks, which is, from what I can tell from my research, would essentially be like a social security trace check. It's often used in an employment context for those who don't have statutory authority, or, well, we have statutory authority, but they don't have access to the same background search that we do. So what it looked like is there's a lot of third-party companies who offer this as a service, mainly for employment purposes. They're like, we'll screen your candidates for you. That doesn't mean that it hasn't also been offered to government, other agencies in other states. I haven't been able to verify that a social security check is more robust or accurate than what we use. Like I said, the trace check was really what I was seeing, and that, that could confirm some aliases or names associated with the social security number. But as a reminder that what we use, we actually have statutory authority to use two checks. We use the DPS, it's fact check, which feeds into like the Texas system to do the background check, and then also the FBI check, which is the national one, and they're fingerprint associated. And I reached out to DPS to confirm this, but because we're the government, we have an agreement with DPS that allows us to use the same databases that law enforcement use, right? To conduct these background checks. And you don't mess around with that contract, right? Because it's such special access to the criminal history record information. So we hit both the Texas specific and then that national database with the fingerprints. But I wanted to reach out to DPS specifically just to confirm that I didn't have this, wrong. I even asked about social security checks. And so this is an email I got from the person who's in charge of their criminal records division. But she just walked through that, we've got that provision under 411 that allows state agencies with statutory authority, which we do have, to receive secured Texas and national criminal history record information, CHRI, by fingerprint submissions. And she says this allows agencies to adjudicate true CHRI for employment licensing, non-criminal justice purposes, because the fingerprint submission can confirm it is the individual of the record. She also says that the fingerprint submissions that are submitted by agencies like us, right, and not you're getting fingerprinted down, because you got arrested, are processed to match other fingerprints that are housed within DPS and FBI to provide CHRI. And so, if an individual does not have prior arrest prints, DPS and FBI will continue to retain those fingerprints, right? So when we ask our license holders to get fingerprinted, they're going to go ahead and retain that. And that's how they can match it to the individual if they're arrested in the future. It allows the clearinghouse to send event notifications to agencies that have a subscription to that individual, which is what we do, right? We have every license holder fingerprinted and we have essentially subscribed to them. But she said, she said she wasn't familiar with the term of a social security check generally, but that fingerprints are what's unique to the individual and will ensure that we have accurate CHRI that was reported to the department and FBI. So all of this is to say that what we tie into statutorily, Department of Public Safety is confident that it's the way to go, that we're getting this access. And we know that based on our agreement with them, like we're directly tapping into these reports, which is, again, I'm just going to keep saying it, that's a very big deal. Only state agencies and other authorized groups are going to have that level of access. If to the extent there is a desire to do a social security check to add to this, it would be a statutory change. But really what I was seeing on the social security checks was a lot more for sort of pre-employment checks or for folks who didn't necessarily have the level of access that we did. But that's something, to the extent you want that to happen, that would be a statutory change that we would add to the list. I just wanted to make sure I had confirmed to you all the system that we use and what what that access level is and why DPS is so confident in it. And it's the one that, there's a whole section in 411 that's like just state agencies talking about their access to this information.
I think we heard about Social Security when we were at Rello, and it was just more of a, hey, let's look into that. I mean, it sounds like the agreement with the DPS for state and nationals is a better search and better scrub. So I don't want to open that statute up.
I mentioned something in the meeting. You said that the way you run background checks is different from like initial license and then renewal license. What's the difference?
It's the considerations, right?
So,
Yeah, that.
yeah, the only difference is in the reinstatement where we review the person's full background, where if it's just a regular renewal, they only take and consider the criminal history that they've had since the last time they renewed. So that just a two-year
Yeah.
window.
Because that's the only thing that would
And it's
change,
only
right?
felonies or fraud-based criminal.
Yeah. That makes sense.
But the reinstatement is like a whole new applicant, so that's it.
Does that get you there? Okay, based on what, it sounds like we can check that we've done that. Okay.
So that one dies? That one that she's talking about? The Social Security?
I think we should say we've accomplished it.
Yeah.
We've done the research. Well done, everyone.
Excellent segue.
Yeah.
Excellent segue into broker succession.
Yeah, I was
Yeah,
gonna
this
say, speaking of death, no, I shouldn't say that, but I did.
Segue.
Segue. So this is a topic that, and I just made it, but I know it's one that gets brought up quite a bit, and it's broker succession. So as a reminder, if a broker dies, then all of their agents, if a sponsoring, we're really probably talking about a sponsoring broker, a business entity. But if the name broker for an entity dies, then the sales agent's license are set to inactive. So they're essentially terminated.
Immediately?
Well, that's a great question.
Do what?
He said immediately.
Immediately.
Well, so this is interesting.
Let's unpack it. Let's unpack
Yeah, let's unpack it. So the thing that you more often than not hear is the broker dies and 300 agents are set to inactive immediately and all the deals die, right? And that's the fear. Yep. And it's like a horrible process. It's really stressful and it takes forever. And that had been kind of what I had heard. I mean, we even had someone on BRAC talk about a situation where, you know, my gosh, it was years ago and this person had brain cancer and it was just such a horrible process to get it switched over. So I'll say two things. There's a regulatory side to this and there's a business side to this. And I think we can address both. But there is no scenario where this is not a stressful situation that requires people to sort of scramble to an extent, right? Even if it's news that somebody has a brain tumor and you don't know how long that's going to be, even that process is stressful because it's a disruption to the business and how it's working. But what you all asked is for us to look into possible ways to maybe even like put in a temporary broker of record or for someone to be able to name a next in line in the event that, you know, someone passes. It's just sort of an auto switch. And so we started looking into that. And Abby and I, you know, we're going through all those ideas and we sat down with Denise and Mike. And we were, you know, we're throwing out ideas like, well, what if somebody names the person? Like, what if we collect documentation or we change a rule and they're allowed to just name someone? Basically, well, we're going to have to do the same thing we do already. And then it was, well, what if, you know, what if X, Y, and Z? And she's like, well, we're still going to have to do the same analysis.
At the time of the need.
At the time of the need. And so then it was like, well, okay, what if, finally she said, what if I walk you through what actually happens on our side? And then we can talk about solutions, which, you know, maybe that's where we should have started, of first walking through what TREC's process is. And I'm actually going to have Denise do that in just a second, but I want to point out, I think there's room for improvement on this. I think our process, once Denise walks you through, I think the process itself actually works pretty well. It does the things that you're asking for, but without having that set person named. Our rule language needs to be changed because the rule language talks about, you know, that immediate deactivation. But what the reality is different. So I think there's room for rule change. There's certainly room for education on our part. And some of that education, I think, can be on the business side of things of, you know, there's this issue of like all the listing agreements die. Well, the listing agreements don't die if they're in the name of the entity and not the individual.
That's correct.
And then, you know, is there a way that you can structure your business on the front end so that you do have someone who's got a percentage where they can step in? And the answer to that is yes. But it's still going to be stressful. But if you can set up in such a way, you know, on the business side of things, it's going to help facilitate the TREC side of things. You know, we also want to be mindful.
That's not true for a brokerage or a broker operating a brokerage as a sole proprietor.
That would be different, right? I think I'm saying that,
But
because it depends on all your documents.
And people
debate, yeah.
But
Yeah.
so I'll throw it to her. Some of the considerations though that we do have when you're naming. So let's say I name Abby as I report to TREC. Abby is the person that I want to take over in the event I die. And I do that at every renewal I name someone. Abby and I get into like an explosive fight and just like, forget it. That friendship is over. She's the worst. I'm the worst. But I don't change that in my stuff, right? Then you've got that. Or what if Abby commits a crime and is no longer able to serve as a broker? So just looking in sort of the realities of how those go, I mean, the one that comes to my mind is a married couple who gets divorced, which is always complicated.
Kids get involved.
So I'm saying all of that, the agents are the kids. But I was gonna have Denise walk through, because I think this is one, I feel excited about this one. I think this is one we can reach resolution on and get something good going.
Go to these.
Denise, make it happen.
Bring your game.
In the case of the death of a designated broker, we will not immediately end relationships or inactivate the business entity broker license. These get routed as soon as we hear about them to a team lead to get somebody on the phone, speak with somebody who's, because it is a stressful time. There's usually a little bit of chaos and uncertainty on who is providing information to us. So they're routed to the team lead to get an expedited explanation of, the requirements. The change of designated broker form is required. They check, the documentation to show proof of managing authority, and the documentation to show proof that the designated broker owns at least 10%. And if they don't, then proof that the business entity maintains E&O insurance. Whenever that happens, what we talked through is, even if, just to use an example, it's Blue Elephant Realty and they've named, Vanessa, the designated broker. She said, Chelsea's my go-to person. We're still gonna have to do that check, even if they just named someone 6 months ago, 2 years ago, however long ago it was, because the requirements are that they're in good standing.
Right.
So that's where it lands in enforcement for all of those requirements, and we're going to check that documentation. So the expedited processing, I think it'd be helpful to know that puts them at the top of the stack. Right now, consistently for about the last year at least, we have been processing regular changes of designated within 3 to 5 business days. That's just the regular old change, not this type of scenario where it's an emergency. So, we talked about the enforcement requirements there and that processing time. So I don't want to jump too much into what you're going to recommend, but it seems like already having somebody named with managing authority, that's kind of the biggest hurdle, is when they come to us, is the documentation that just has that one broker that's no longer with us as the only person who can make managing decisions. So one solution would be name 2, and then your managing authority documentation is already there. It's just a matter of getting that to us, providing the name of who's going to be the new designated broker, and going from there. Yeah.
How do you find out when someone dies?
We're typically notified by family members or, business partners. I mean, really, it's just the sales agents that kind of don't know what to do, but typically it gets routed to the team lead, because we need to now find someone who's in charge who can get us the right documents so that we can get a new designated broker.
Worst case scenario at next renewal.
I like, go ahead.
I was just secondary question to that is, we've talked about under business entity, but what about brokers who are just sponsoring people under their individual? Then is there a difference in the process at all?
No, I mean, not really, because that is an online self-service tool. Is, whoever's going to take over sponsoring those agents can just make the request
New invitations.
online.
Gotcha.
Yeah, or the sales agent can send requests to new brokers online.
Cool.
It's the business entities come up because that requires someone at TREC to actually review those documents and make sure that the specific requirements for a designated broker are being met.
Just
I
having
like
a
where you're
grace
going.
period, so you don't bury somebody one day and you've got to have somebody the next.
Well, and that's an excellent point. And I think one of the things that Vanessa brought up was what we do in practice, which, when Mike and I were meeting with Vanessa and Abby, we're like, well, yeah, I don't want to speak for you, Mike, but I know you said, yeah, we wouldn't go after them if they're getting everything in order within those 10 days. So there's the matter of, possibly getting the rule to speak to that process, to maybe lessen the stress whenever that situation happens.
I like where you're going. What I don't necessarily like is what says codified grace period. I was told this morning that previously this was brought up and they said, well, you know, we don't want to have someone in backup because what if they die? And so what we'll do, we'll just give them a 30-day grace period to get it taken care of. Well, grace period's grace period. And so, I mean, the way ours is set up, we have 3 people above 10% ownership. And you have that article of incorporation. So it's on file. So it should be very simple to move somebody. We've seen it happen 3 times or 4 times in the last year where it is just, it's a mess for the agents and everybody involved. So I like the idea, if they're already named on the articles of incorporation or whatever it is, more than 10%, you know, just move it. That grace period is so subjective. Do I get the same grace period as Chance?
Do you think that should be in rule that, you know, pull out is it immediate? Is that what the rule says?
The rule says.
Yeah.
And like plug in, I mean, it's not that simple, but
Within 10
anytime
days. You go, well,
We'll just use the vague legal reasonable.
yeah, reasonable. Oh, well, we'll ignore it for 30 days. Then, yeah.
because some of that depends on diligence, right? So I mean, it sounds like we won't go after them as long as they're working to get it in order.
So is the solution just a 30-day reprieve to get it in order?
I don't know what the solution is, but I'm glad we're getting, I like the thing about it. If it's already there, it's quick, but.
In your case, out of curiosity, just from this perspective of having a backup to the backup that you were talking about, do you have 3 because one of them is your wife?
No, my wife is not one of them.
Just out of
Let me
curiosity.
say, okay.
Just out of curiosity.
It's all hers, but she is not one
Right.
of them. She does not have a broker's license.
Okay.
I have 2 with broker's license that are percentages just in case.
2 other wives?
No, 2 other ones.
This,
Yeah, no, it's,
the scenarios you brought forth with where this came up recently, they didn't have that sort of setup.
They
in
didn't.
place, right?
they
Okay.
didn't.
So some work on a communications campaign on getting,
Yeah, and they were managing property and people paying rent and calling in repairs, and
yeah.
it was a mess.
And there's room on the broker responsibility course, right? We started educating best practices, right? So there's best practices associated with this on the business side to facilitate
Right.
the TREC side.
But that was not named. That's good. About have your articles there with
Right.
someone more than 10% or E&O in line. That's not in that.
Right, but I think we could, as we develop the new book and then we put out a communications campaign. I'm hearing a little bit of conflict in terms of a rule change.
I like his, reasonable instead of immediate.
Yeah.
I know attorneys don't like that.
What's reasonable?
Yeah, I don't, but you have to define that.
Idiots.
We were thinking
I don't think
10
we're doing
business
our-
days.
10 days. I'm fine with that. Yeah.
So, okay, so we'll get some draft.
10 business days is reasonable.
Yeah.
To do what?
Yeah, I agree.
Get-
To get the
somebody
new
else in
broker in line,
charge.
in place.
That's right.
Denise has some clarification.
I'm gonna
Yeah,
turn the document in 2 minutes.
I was gonna,
2 days.
I was gonna speak to what you brought up, Chair Kestner, that, you've got your ownership structure established to where it would be easy to provide the document.
Right.
We would still need the change of designated.
yeah,
or,
yeah.
To.
It's, I think it's
the
done.
business license number, but you're right, the leg up, the advantage that you would have is that you don't have to go draw up new paperwork that demonstrates who's got the managing.
Right.
authority.
Yeah.
Structure.
10 days, they're bereaving in 4. They already lost 4. And then they gotta
Get to the paperwork.
get the paperwork to track.
You're assuming there was a long bereavement process.
You don't know my family.
They're making plans.
It could be a
It's already
celebration.
drawn up.
But you know what? It's your agents, it's your principals, it's your properties you manage, it's everything.
I think 10 days is too short, but I
Too
will,
short.
yeah,
30.
yeah.
30's a long time.
15.
I like 10 business
So
days.
how about a broker that doesn't have your structure.
But you know what? That's why we have the broker responsibility. And if he is leaving his people out there 30, I'm sorry. If their people, he's not leaving anything for 30 days, yeah.
And how long do most contracts take to close?
30
30
to 45 days, but
So-
you have
so-
listings, you have properties you manage, you have agents
Yeah.
you sponsor.
So you're just wanting a substitute to come in and take responsibility for the.
10 business days.
Within 10 business days.
Which,
Man, 10 days is,
which if we have,
I get it, but
and I brought this up to the previous administration here 10 years ago, there needs to be a broker succession white paper. There needs to be something on file that's how to, or a series of best practices, broker succession,
And I think.
and
we
what
can-
that ought to look like.
And I think you mentioned the landing page too, like a place with resources like that. So that we can definitely explore in terms of what we do and educating and getting that message out there. It's the number of days that you want to give in grace period, or if you want, you could, you could say something now. If you want to kick it to a committee, you could.
Well, I heard 10. Is anybody opposed to 10?
Business days.
Oh, well, we don't do
That's-
I don't, I think.
No,
No.
then, no.
You don't do what?
it needs to be longer.
15. Do I
I'd
hear
say 30.
15?
So did you
30
say you
days.
don't do business days, you do?
Well, we do just calendar days because what is a business day and who's counting?
Yeah.
Saturday and Sunday are not.
Yeah.
If the 10 days falls on Saturday, Sunday, you're legal
Yeah.
holidays.
If a Friday's an even number day versus. an odd
The
number
laws
day.
we make.
So we'll propose, like, when we work on a rule, we can start with like a 30-day something and then we'll go
Okay, 30 days.
30 days. And then you might change your mind, or they might tell you that that's a terrible idea, and they'll tell you why.
30
Okay,
days is a long time. They're gonna sit on it for 20 days and then, yeah. Anyway, yeah.
like a,
If I may, I know, like, when we were setting our license application processing times, we had always reported in terms of business days, 7 to 10, and our system doesn't care about calendar days, or
business days?
sorry, excuse me, our system does not care about business days because we take applications, they're open 24/7 as long as the
Yeah.
system's up. So we set it at 14 days, and that covers essentially 10 business days. It's kind of a 2-week sort of
That's fine.
turnaround, but then that I don't know if that's helpful to you, but that's kind of where we came up with that benchmark.
So what's the usual normal practice? What have you seen?
For this type of change, we are getting those out in 3 to 5 business days.
They contact, when somebody dies, somebody contacts you and changes the broker?
That's the normal process, when it's not the death of a broker.
No, I'm
So
talking about when somebody dies.
Yeah, we get to the top of the stack faster. Same day, we can get all those documents. We cut them in front of.
But how often do they, how fast do they respond when somebody dies? What's the norm?
Usually that's why it's routed to the team lead to get that direct communication. Here's my direct email and phone number to get those documents back to me, or if you have questions. They're usually pretty eager to get the new broker in place.
5 days, 10 days, 14 days?
I think it depends, really. It depends on how the documents were done, but I'd say, just throwing a ballpark, probably within a week.
That's not an issue.
So if you were making a rule of 14 days.
I would say if the challenge is business days versus, and.
They're talking, if you do just normal, like if we just say calendar days, should it be 10 or should it be 30 or somewhere?
It's like 15 kids.
Yeah, but that's administratively, you can, I know you can handle it. You can do it within
Yeah.
the same day.
Is it reasonable for a?
Is it
For them to
reasonable
go
for
back and get the.
15
a
days.
grieving family to get you all the paperwork? That's my concern.
Well, and typically there's someone else, just in the ones that have made their way to me. There's usually someone else, a family friend or business associate, somebody that's helping. It's not generally the immediate family that's having to deal with it.
And in some situations where they may not have a second person and they gotta go find one that's willing to take that on, right? And so that complicates it a little.
And hopefully the broker responsibility working group is calling their attention to that for the last 4 years, really, the last 2 classes.
the course.
And we've been calling their attention to it, but we haven't had a way for them to do it.
It's not
Does that
important.
make
It's
sense?
not important to them till they're dead.
Right.
Yeah,
And then it's
and it
less,
doesn't matter up to them.
But there's, maybe that's.
not important until it's less important, and then it's,
Like for
It's not
the
important.
person who's like, oh my gosh, what do I do right now?
I like this. I like the 14, 15 days. Yeah,
Okay,
the white paper.
okay, so then sounds like this is a thumbs up. This is not a statutory change. We can start work on this. We'll bring you a rule in May.
good.
Love it.
Okay.
That'd be a
14.
good time
And
to
then when-
discuss.
On that first bullet point.
Round it up to
What are
15.
we gonna write a white paper and get it out to people? Are we going to, how are we gonna educate this?
Well, don't you gotta go run the process and
Make a
get
plan.
feedback and all that?
Let's get the rule.
Sure, I think we need in a new course, right? And then I would think, this is my favorite part of any meeting. I'm gonna volunteer communications. To do a little bit, they could do a little bit of a campaign that's perhaps more engaging than that. And then I can't really like declare a website resource because I have no authority, but it seems like we could explore those options.
But you still gotta run the traps on the rule change, right? Public comment, governor's approval, all that.
Now, our current practice allows for that, we're currently, just because we're nice, providing that grace period, because it doesn't seem reasonable to yank something immediately upon death. So I think we will continue. I don't think there's harm to anyone there. We'll continue that practice
So you-
and get our rule to.
So you mentioned the flip side of that is the business
It's the
aspect.
business side.
But that's their thing, right? I mean,
Right, but we can educate of like, here's some things that will make this easier.
Naming somebody in your corporate agreements.
Yeah.
those kind of things.
And so we could do that, certainly. I mean, if it eliminates the stress and it has people more organized, then it ultimately leads to a quicker change.
Yeah.
So we can do that.
so just throw one more thing out there. And I know I've seen this because it actually came up on the CPA side where they couldn't even get to the guy's office. I mean, everything was locked. And you couldn't go in there because that's not your office. You'd be breaking an entry. And so those are the issues that, access to the files, computer passwords, all that needs to be ironed out.
Yeah, that's. And so I think we can point to that as we walk through best practices. And then there was one other part, but I can't remember, but I think, does this seem like a good,
Good about it?
Get it back.
Yeah.
I feel good.
oh, that's what I'm saying, and we can get rid of the myths around what happens. I think that's a big part of it.
Big bad,
Yeah.
not so bad after all.
Actually,
You guys are lovely.
Okay, this is the last slide before you get to the legislative initiatives list. Okay, ESAC today, the new chair did his report and he made a recommendation. And this recommendation will actually tie to another legislative item that's coming up, but their discussion point, their ultimate recommendation was to require principles 1 and 2 as a prerequisite to other qualifying courses. That would be a statutory change if you wanted to pursue it.
I have
Statute.
big issues with that on two bases. You have a small school. If I decide to get my license, I have to wait 8 weeks if I take the night classes, 6 weeks if I take the day classes. If I decide to go to a community college, I looked at 2 of them, and I want to get an associate's degree in real estate, I can take principles 1 in the fall and principles 2 in the spring, and no other real estate classes that entire first year until I have those 2 classes. And until I see hard evidence that you need those, I just think it's a bad idea. I think it lessens the people trying to get into the business. In the perfect world, 1 and 2 is probably the best way to go. But I bet 70% of the people that work for us did not take 1, 2, and then the rest. They took 2, then maybe agency, then contracts, then 1. I don't see that going to the legislature and changing that.
Was this
agree.
precipitated by anything, or is there any data behind it? Or do they just come up with it?
I think this was part of a bigger discussion. So they opened up the outlines for principles 1 and 2, and you know, Chuck Jacobus feels very passionately. He wanted like a redesign of the courses, and then it sort of led to this conversation of, you know, if principles 1 and 2 is the ultimate foundation, why are you able to take it as your last, you know, qualifying?
Yeah.
I took freshman English my senior semester in college.
Sounds like.
Still got a degree.
Yeah, exactly.
That's the best thing I've heard.
I mean, they were looking at combining 160-hour class, which to me is really crazy because if someone fails the state part, you send them the principles 1 and the national part principles 2 for retake. And with 60, it would just be, anyway, then it came up with this. I mean, I looked at EPCC, something, you know, schedule for an associate's degree in real estate, and it was 1 in the fall, 1 in the spring. And just, yeah,
Well, I mean,
see it.
this is why you have committees, right? They dive in and then you all workshop it, and it sounds like this is not one specifically on principles 1 and 2 that you want to take up.
So that one dies?
That's a strong word. It's not reasonable.
Fails for lack of support.
Fails for lack of, I get it.
Okay.
I like that.
And then we've got 2 inspector items. 1 would be a statutory change that would require apprentice education. I can't remember if I was supposed to stop talking on this one, or do you want me to keep talking?
Oh, I've loved it.
Okay, I'm just gonna keep talking. So apprentice education, this is one that came up. The inspector committee has made this recommendation, but this group has not workshopped it yet, and it would be a statutory change. So this would be a 4-hour pre-licensing course on the apprentice license. The thought behind it being sort of a foundational course so that when somebody gets their apprentice license and they go work under supervision, that they have at least had sort of some of the basics before them. Do you want to say?
No, I was just gonna say it's that, as well as so they know what to expect from their sponsoring inspector as well, because so like what the obligations are in both roles going forward. That's sort of the idea behind this 4-hour course.
So right now it's only like an exam?
We get that.
They don't even take an
So
exam.
an apprentice one, you don't take because the thought behind an apprentice one is that, I mean, there's a whole series of requirements once you get that license where you work under supervision of a licensed inspector. You do I can't remember the number, but a large number of supervised inspections.
So
You
if they're not,
essentially work on or learn on the job.
if they're not licensed, how can you enforce an education requirement?
Well, there's an apprentice license.
They're licensed, but they have direct supervision from their supervisor. They cannot go into a house without a supervisor, a supervising inspector present.
Okay.
And then it,
Okay.
like, so if you're going the course of the apprentice, you know,
Student driver.
it's a
Yeah.
system, like a tiered system.
Yeah.
So then you can graduate to
Yeah.
Indirect, is it indirect supervision?
Yes, and when you get to be a real estate inspector, then you're under indirect supervision,
Which is different than a professional inspector.
which is the ultimate.
Which
No,
supposed
electrician.
to keep them from leaving the room when they leave the water running type.
That's true.
Yeah.
Okay, I like the idea. I mean, I think it makes sense. It talks about a statutory change. Would that not be easier to do with the next one? I mean, if we're opening the statute, removal of real estate inspectors, so they would just go from an apprentice to a professional?
That's the thought behind that particular thing. But yeah, exactly.
And that came from, I mean, I don't know why that's good or bad.
That's been something that's been on the legislative agenda for several sessions. It's just something that's been out there. I mean, I don't know if there's thumbs down for it. It's just been out there as a thought because we're the only state that has a three-tiered inspector.
But would it be easier to dissect for the legislature to get rid of that middle license type if we're adding some education to the very basic?
I think you
Would
could
that
do
be
it that
any
way,
easier?
or they could stand alone. It could be either way. That mid-level license right now is hardly utilized. Because most people who become inspectors go the professional inspector route. They basically go the education route rather than working underneath someone.
I like moving this.
So they could stand alone or they could go together. And one question we had is, do you want to keep pursuing this elimination of the mid-tier? It seems reasonable. It hasn't passed for several sessions. I don't think for any reasons related to the merits. It's just succumbed to the legislative process. Not utilized significantly, so it's kind of like.
But it is utilized, and so you'd have to keep the license in the system.
Yeah.
So we're already building in the system. And it's going to change that jump from apprentice to professional, like we just talked about the indirect supervision, right? At the mid-tier, but at the apprentice tier, it is, it's directed supervised inspections, essentially direct supervision. So there will be a need to toggle, and this is not, for or against, it's just the reality of it is there'll be a need to toggle. Okay, so then if you've gotten rid of the middle of that second step, what does it look like to go from an apprentice to a professional inspector?
Is it an easier trip to get the apprentice education and leave the real estate inspector license time? Because I like the apprentice education. What would be an easier?
I don't think either one of them are easier or less. I think that the difficulty when you combine a bunch of stuff, I'm just speaking factually here, is if somebody doesn't like the removal of that, then you put the other item at risk. But it doesn't mean you can't do that, because people do that all the time. But that is a possibility, a possible
Well, it might be easier to just do the apprentice and not even worry about.
So are they now, I assume apprentice education means you learn and then you do on-the-job training? Is that where the second one comes in? And then the third one? I don't know. It seems like I do the education and the follow along training. And once I completed those requirements, I would go for the real estate inspector. Why wouldn't the education and the follow along training be good together?
So the apprentice license currently is just to get you in the door. So you get, without the education, the way it is now, you get your apprentice license, you go and work under another supervisor. And as you're doing that, you do take education before you get your real estate license. You have to pass a test. You have to take education and do a number of inspections before you can take the exam and pass it. So that does currently happen now. What this would be is before you could even get your apprentice license, just a 4-hour course kind of telling you what to expect from not only what you should be doing, but also your relationship with that supervising inspector.
I think Mark made the best analogy. It's like being a student driver. You go get a permit, you drive under supervision, and then you get a driver's license after you pass a test.
Yeah, exactly. That
makes sense to me.
Yeah, absolutely.
Right now, there's a middle level of indirect supervision, and I think isn't there additional education?
There is.
Is there an exam? And an exam. Now, most people are going the education route regardless, right?
Sure.
Because there's an education path.
Why wouldn't you?
But the question is, do you want to eliminate that tier and do the work of figuring out what number of inspections? Because you're going to change your apprentice license unless you're just going to say, no, just eliminate it completely. And it's just, 200 supervised inspections. No, if you're going to keep your apprentice the same and just truly remove that middle level, or if not, you've got to go in and figure out, well, what are you going to apply from that middle tier license now to the apprentice license?
I'd combine 1 and 2. Just combine that, and once they've done that, then they get their license for that.
It sounds like there's consensus around the apprentice education and more conversation to be had on the second one. And how do you feel, and I'm looking to you to make sure we can do this. It seems like we kind of move these forward with the second one being, let's see what it looks like and kind of put a little bit more meat on the bones with the inspector committee, and see how it turns out.
Yeah, we like it, but how do you?
Yeah,
also-
just
What does it actually end up looking like? And that's what they're prepared to start looking at is what it would look like without that middle tier. I think the consideration too is on the TREC side, and what does that end up looking like? And as we're moving to the new system, is this the time? And is it elimination, but some people are gonna keep it forever, in which case, have we really eliminated it? So those are all of the considerations, but it does sound like let's keep exploring it, and see where we land.
Great. And I got just one final thing is if the consensus of the commission is to move forward with both of them, they don't have to be in one bill. They can still be in separate bills if there's some concern that one might go further than the other. So
That's why we have the two groups.
Okay, and then I think the last one is the list of legislative items before we get to email addresses.
Yeah, okay, so we've done this, but we've done the work on this. This is just kind of a matter of where did we land? So I'm gonna read through these and we'll make sure that we know.
With the first one being one that was previously discussed by the commission in a workshop, given a thumbs up, want to make sure the thumbs up is still there for it. It's the only one we haven't discussed today, I believe, sorry. But this is that requirement for the broker responsibility course, to be a requirement for both just a broker's license, and the broker's license renewal, regardless of whether they're choosing to sponsor anyone.
Yes.
So if everyone is still good, all right,
Good.
it seems like everybody loves it, okay.
Okay, so then the next two, I think we know. Display broker associate affiliation on the website and provide notice of broker associate complaint to the brokerage. So that we're gonna work through that. Require principles 1 and 2 as a prereq. We're not doing that. Provide agency with rulemaking authority to establish qualifying, we have not talked about this one. Qualifying course content and pre-licensing education requirements. This is, you want to talk about this?
I'll pick that up. It's not dissimilar to, it's very similar to what was done with the broker pre-licensing education requirements in the last legislative session, shifting that rulemaking authority over to the commission rather than defining all those terms in the statute. That gives us a lot of flexibility for any changes that any subcommittee might recommend, that any, that the commission might feel there's value in. I think that, to me, what this does is, and for those of you who may not know, I know that you know that ESAC does a lot of reviewing of the content outlines for the qualifying courses. What you may not know is the baseline of the qualifying course content is in the statute. So where we have, like for Principle 1, we have a course approval form that's 3 pages that has all of these topics and subtopics. What's in the rule, what's in the statute is something separate. It's much smaller, but for each course, there is a Texas-specific component, okay? We have found that we get, with military applications and with out-of-state broker applications, with individuals who have taken courses at colleges and universities, particularly outside of Texas, there is not a reasonable way for us to accept any of that qualifying course credit. So while what this is really about is just the concept of shifting the authority in case any of these other discussions are of interest to you. Since ESAC is already in the process of revisiting the principles courses in law of agency, is there any world in which you could see a benefit from removing Texas-specific content from the existing pre-licensing courses and creating a new course that is all Texas-specific content, allowing some flexibility for those who come from an out-of-state college and have taken real estate courses, to use some of that education to get into the industry in Texas,
yet still having that requirement that they take all of the, that they learn all of the Texas specific information in another course. And again, that is not like the actual recommendation, but it's the only way that we could get somewhere like that, somewhere,
That would be step 2. Step 1 would be to pull out the requirements from statute, put them in rule.
Right.
So do you want to do that is the question.
Yeah, and with that would be pulling out the establishment of the specific courses for the sales agent license and then shifting that authority to rule. So thought,
So that
I know
would
some
potentially-
commissioners, I'm sorry.
No, go ahead. I'm sorry.
Well, I've heard some commissioners consider that maybe real estate finance isn't an appropriate course for pre-licensing sales agent education. We can't do anything about that because that's required by the statute. If there are things that you think may be more helpful for a sales agent who's preparing to get their license and preparing to enter, get into the industry for the first time, shifting that from the statute to the rule could allow this
More
commission flexibility.
I like our staff to have the ability to do what we think needs to be done in education without having to go to statute. So, yeah.
How heavy of a lift is that?
Well, we did it with the broker education last session. I don't think it's just a matter of talking to the stakeholders and seeing how
To get TR on board with it.
Yeah, but again, it provides nimbleness and you don't have to go hat in hand to the legislature every time you want to make a change, which is very
I think
difficult to do.
it's a great idea. I'm just
And we're
curious.
not lessening the hours.
That's right. We could just, and this builds on what happened last.
Almost housekeeping.
I really like this. I mean, I don't see any bad side to it.
Cool.
Okay, good. Okay, and then we talked about the 2 inspector ones. So I think we're good there. I want to just tell you kind of what tends to happen next before we go to the email addresses, just on the legislative front. We work very closely with Texas Realtors. We also will work with TLTA. Like, we'll reach out to them and just say, are you ready to talk initiatives? Sit down in a room and say, okay, here's, what do you want done? Here's what we've heard from our license holders, and basically see where we have commonality and what we agree on. I've never seen anything succeed that TREC has proposed that hasn't had the support of Texas Realtors. Like, that support is necessary. If there were something that we would need the support of for like TLTA or another stakeholder group or the inspector stakeholders groups, we can't go forward and do something that the stakeholders don't support. It's just not
That's where the
viable.
money comes from.
Well, and when you go to a lawmaker and say, we'd like for you to carry this bill, the first question they ask is, who opposes it?
Sure.
And the answer has to be nobody. And you
Yeah.
have to have done your homework on it. So we'll do that. Of course, we do not lobby, but all of these items are cleanup items or things that we've heard from and that we just kind of talk through. And then we won't lobby the legislature during
You get
session.
TR to pick it up.
Yeah, and that works. They want it. I mean, they don't want us to be in
So-
the mix.
So in regards to
Yeah.
sending them separate, wouldn't it be better to package them all into one?
Maybe not. I think it depends on what a package looks like and who a good author is and how they like to work. And all of those things are good to not have to hold loosely until just see
And
how
also just the fears of whether or not you really think if there's something, like if you put a bunch of stuff together and there's a couple of things in there that you're just not certain is a home run, it might be better to pull them out. 'Cause you don't want to kill the whole bill because there's issues with one or two
Your hedging,
things.
Yeah, exactly. Okay.
or
Any-
attach it to like another bill that
Right.
completely has nothing to do with
Absolutely.
it.
So we basically have a plan legislatively. So if you have things that you want added, we need to then it's probably good to just talk to the chair and you can bring those up, or those can be discussed at the executive committee. But really, this was the beginning of that process. Email addresses, y'all, we're close to the end, and it's not even close to 5, and we could just sit here and chat until then if we needed to. I'm kidding.
We could, yeah.
Um,
What we want.
At any moment, there's gonna be a bunch of IT people that come storming in this room to help you. No, so if you'll remember at the last workshop, it was raised of, hey, these emails go to our personal email addresses and the good and the bad, and how different people, handle that. Some have specific email addresses that they forward to that are for commission emails. Why is it on the website? All of those things. And Chelsea sent an email probably a few months ago at this point, as part of her weekly message that said, we've looked into this. And while it's always been an auto forward, right? So given us the email addresses you want your emails forwarded to. You do actually have Microsoft account, like a full email like I do on my office. On my computer. You have full access, an inbox. If you were to log into it right now, it would have every email you've ever received as a commissioner. So, but we haven't given that access because there was a preference in the past to have it forwarded. But in talking with IT, they were like, oh, it would actually be wonderful if it was through the Microsoft account for purposes of security and us being able to control that. In getting to that and finding out that the accounts already exist, the thought was, we can give each of you your login information, help you to download the app if you want it on your phone. They're on their way. They're coming to help do that. It does mean, that was the other consideration, which is that even though if somebody emailed you, let's say at leslielerner.trec.texas.gov, the only way you could reply was with your personal email address. And so what this allows for you to have a TREC email address that you respond to. So we would still have all those email addresses up on the website, and I think that, that's helpful in the name of transparency, and, Commissioner Rogers was talking about earlier, being able to reach the commissioners, but this would allow you essentially your own account. It would mean that you have to check it, right? It'd have to become part of your practice of checking this account.
Right.
But, I have it separate, and I know what, you just click on that link and you look and you see, oh yeah, okay, this and that. It'll allow you a place to respond from, and you can still forward it to your personal email if you need to. The recommendation is not to, to keep your Outlook stuff in your Outlook account, which from a government perspective is also great. But I would say one more thing, which is, it's a little bit unrelated, but I do want to address one of the comments we received.
So if we do go that route, can we still have communications from you all to our personal email?
If you want that, I believe they can set that up.
It sounds like a no to me.
Sound like a no to me.
It's not ideal.
It just muddles your inboxes. So we don't often get public information requests for any and all emails sent to Centennia. But if we did, then we would need to be looking two places. And it would mean that we are looking in your personal email. So it kind of opens you up more than anything. Is that fair?
Yes, that is fair. It is possible if you want it. It's just not our advised way of doing it. You're saying like every email that, like, for example, Chelsea and I send you.
Right.
It's also gonna be every agreed order. So, which is the majority of the emails you get from us. I believe that's how it would be set up though, again.
Yeah, but if you get a public information at request, then they would be in that TREC email, right?
That was if you forward it. If you keep it forwarded, then it would essentially be both places. Right?
If you're responding.
I don't want it forwarded. But I want your communications to go to my personal one.
Yeah, so I think that I'm looking at Alex. I do think if there's interest in that, there is a way to write a rule.
Yeah, I'm kind of in that camp.
Okay.
I may not check the TREC email every 10 minutes.
No, I will not check the.
Well, let me just say I won't.
No,
But
I
if
do well
you
to check
you
my
two
own
send me
email,
something,
not
I
the
probably.
Right. So we can have that that conversation. That's initially we had thought that that was gonna be something that was requested. We really wanted to encourage just use of the Outlook for, especially for purposes of the back and forth. But if you want something that's from staff, I don't even know if it could be like a specific list of people. It can. So if you just want emails that come from, you know, Chelsea, Tony, Vanessa, Amber.
And the reason is that,
that'd be-
you know, I get all, as some of you may have, it's like, you know, different campaign emails from different
Yeah.
lobbying organizations.
States.
Yeah, that I'd rather not. I mean, it just.
Yeah, yes, I get those too.
So I won't monitor my ben@trec dot whatever. And if you have any communications from staff to me for meetings, agendas, send it to my work account.
Well, I think we would still want you to check it because of the possibility of, you know,
Member
people
of the
reaching
public.
out to you, yeah. But it would certainly probably be easier if it's all in this, you know, you
One
do a little bit
place.
of a skim.
Yes.
And pull
And
out the ones.
What you were saying, because you were looking at Alex, is what we would still do is send you that email at npena@trec.texas.gov, but it would auto send those email messages from me or your list, whoever you want it to be, to your personal, but not if it came from someone outside of that list.
Right. And that'd be fine. I mean,
So you get those more immediately and then you check the TREC account at your leisure
okay.
for the rest.
Fine.
Right?
Yeah. No, that's right. I mean, I think I just want to encourage everybody to check that email, you know, daily or because, you know, you've got agreed orders. Don't let it just go into a void because it is the public and our license holders' way of getting a hold of you. But I also, I mean, I understand what you're saying.
They've called me at the office.
Yes, I know.
So
Yeah, they're gonna.
they can get all of
It
them.
will find you. So there's that, and IT is here. We've printed some instructions, but IT is here to help you, get everything set up. And then finally, this was something that, Commissioner Lerner had, and it doesn't have to be finally, but finally in the things I'm saying to you, Commissioner Lerner had mentioned, in response to Chelsea's email was, having it where you click, if you're on the TREC website and you click to email someone, that it like pops up essentially a form and you can just quickly type it in like that, which, you know, you've seen other businesses that have that.
Yeah.
And so, yes, that is an option. And yes, they are working on it. It is not currently live. But that will be, like, we took that feedback and that will be something that's coming very soon.
Good.
Now, hopefully I can stop talking and IT can IT things.
Who wants help figuring out that email setup? Or do we want to just
We can do
conclude
that.
the meeting and
We can do that too and give you your login info.
Let's, the last thing here is potential workshop agenda items.
And then,
I have a potential workshop agenda.
Oh.
Okay,
I brought this up to Tom earlier, and I don't know where it fits in, other than it's funny that we're talking about emails, because I think it affects almost every department, is when somebody goes into whatever, My License Online Services, whatever it's going to be called in the future, and accepts an invitation for sponsorship. As they go through the submit, new, next, you know, whatever it is to get back to the front, can we have a place where they confirm their contact information? Because, for example, if Blue Elephant, since apparently that's our example, since Blue Elephant gives all of their agents a blueelephant.com email address, when that person leaves that brokerage and goes to work for White Elephant, they don't change their email address. So all notices from the agency, all newsletters, all enforcement, everything's going to go to that old email address that is no longer monitored.
so just confirm the contact information.
Yeah.
okay.
So it populate, is that what you're saying? Like you're changing brokerages, it populate what's in your contact?
Whatever the next screen it goes to is, confirm that they have the right information.
it's your login versus your business information. And like, it's
If you have
smarter to
a-
use your.
That'd be good.
Well, it's no different than when you renew your license and
Yeah.
they ask you to verify.
Exact same screen.
We
Okay.
can work on that. We'll figure out viability on that. That may not even need to be a workshop. Well, we could maybe just give you an update. I don't know if it needs to be new database, old, we need to,
There'll be no
Unpack.
workshop in May, but maybe that's something, maybe during executive in May, we can kind of throw it around for an update if we have one or something.
yeah, well, and if I can get an answer, that's something I can just let y'all know about on a Friday or
Okay.
any day.
All right, what else? All right, move to adjourn at 2:55.